so far as this
Yes,
page 385.
Affidavit of the chairman.
Yes, this is the, my lord, opposition of the board,
Page 385.
385. It will not starts, my lord, at page 378. My lord, Deputy Secretary, my lord, affirm this affidavit on behalf of the board. And page 385, first paragraph, last two lines. It says, my lord, the panels pertaining to 2016 recruitment process expired on different dates between 30th January 2018 to 22nd September 2020. So, my lord, this statement will show, my lord, there was no panel at all.
Why?
My lord, kindly see, my lord, the panel, my lord, its statement is the panels pertaining to 2016 recruitment process expired on different dates. 2 years, my lord, in between 2 years. The different dates. And my lord, it was also say how this panel was prepared, how this was done, nothing has been stated, and only this statement is there. The panels published on in 2016 recruitment process expired on different dates.
Yes.
Now, my lord, so far as judgment is concerned, my lord, first judgment I will be showing the ratio. That is
You tell us the proposition.
proposition, my lord.
The judgment.
These 2000
Paragraphs. What are the paragraphs you are giving?
my lord, first,
Uh,
my lord, this is, my lord, unreported judgment, my lord. WPAP 203 of 20.
paragraph.
Lord, paragraph 16.
16. Yes.
WPAP 203 of 2022.
16.
Paragraph 16, paragraph 17. Paragraph 19. 16, 19, 21, and 22. Well, this is in respect of same selection process. A public interest, what happened in this case, the background of this case.
The public interest.
What is the background? A person was working as primary school teacher in the district of Uttar Dinajpur. Now, one day, head teacher of that particular school, asked for his appointment letter. The appointment letter was given to him. The head teacher, did not hand over the appointment letter to him. Second day, head teacher told him that don't come to the school on and from tomorrow. Now, he moved the repetition before this formal court, saying, that I was given an appointment, but subsequently my appointment letter was taken by the concerned head teacher of the concerned school. Now, thereafter, a report was called for. Board has said he did not pass state who have wrongly given his appointment. Now, he has used a reply to the report filed by the state. He has stated, the look here, I was appointed. There are so many persons who are appointed in the same district. Now, learned judge took the repetition and transformed into a public interest litigation. Now, the matter was pending before the honorable division bench. The division bench was hearing the matter. Now, in the meantime, what board has done, board has filed an appeal challenging the order passed by the learned single judge. In the appeal court, board has taken a 100% U-turn, saying, no, he is having all documents. He is having all documents, he qualified test, he is a better candidate, best candidate. So, what honorable division bench has done, set aside the order of the honorable single bench. Not only that, honorable division bench treated the public interest litigation as on days list, and it was disposed of. Now, subsequently, I filed
that paragraph.
Now, if you if you allows me, then I can place
not
it.
Allowing you, you have given the paragraphs. We
Yes.
will look into it.
Kindly turn, kindly page 6, paragraph 10.
You have not cited paragraph 10, 16, 17, 19, 21, 22.
Sorry, kindly turn to page 10. Facts is there, page 10.
We shall look into
Yes.
it. The proposition, what you are
The-
submitting, that there was illegality and
Division bench came to a conclusion there is an illegality in the entire selection process. And this order was challenged before the Honorable Supreme Court. Supreme Court did not touch this order. This is in respect of 2016 selection process. Milord, kindly consider one thing. In the single bench, board is taking some stand. In the division bench, board is taking contrary stand. And on the consent of the parties, Milord, the appeal was allowed. Order of the single judge was set aside. Not only that, the public interest litigation, which was hearing by the division bench, bench number 1, division bench number 1, that was taken into consideration and treated on day's list, and it was also disposed of. Kindly see, Milord, paragraph 10. Kindly see. Page 6, or running page 6, paragraph 10. May I just place it, Milord? Record reflects that WPA 265 of 2019 in the matter of Swadesh Das versus State of West Bengal and others was filed earlier, wherein an issue was raised that 12 candidates were given appointment who were not having requisite documents relating to TET 2014 qualifications and participation in the recruitment process of TET. Learned judge, taking note of the fact, by order dated 27th August 2021, had converted the petition number 265 of 2019 into appeal and directed for placing the matter before the Honorable Chief
this is
Justice.
pertaining to TET 2014.
No, TET is the mother.
Maybe
TET, it is not from TET 2016 recruitment person comes.
or
Without TET,
which-
there cannot be any 2016
next
recruitment
judgment,
person.
next judgment, Mr. Diwali.
Well, in this judgment, my lord, if your lordship, my lord, kindly see, my lord, paragraph 12 once. What 12 says, my lord? It says, my lord, meanwhile, the order of the Honorable Single Judge dated 27th August 2021, passed in WPA number 265 of 2019, was challenged in appeal in matter number such and such. Division bench number 4, by order number such and such, only dispose of the appeal, setting aside the, not only dispose of the appeal, setting aside the order dated August 27, 2021, but also dismiss WPA 265 of 2019, which was being regularly taken up by the division bench number 1, that is the Honorable Chief Justice. The DV number 4, while disposing WPA 265-2019, held as follows. Now, we will kindly see last. Since we don't find any element of public interest, the order impugned dated August 27, 2021 cannot be withstand, and the same is set aside. The instant appeal is such and such. In view of the finding recorded above, the writ petition being numbered is also disposed of. But there must be a limit of fraud. These are the instances of fraud.
Next with judgment, Mr. National Fertilizers.
Now, we learn in National Fertilizer,
Paragraphs.
paragraph 2006, volume 5, SCC 493.
Yes.
2006, volume 5, SCC 493. My lord, paragraph 23, 24, and 26.
On the point.
On the point, my lord, that recruitment rule was not followed. But running page 27 of this spiral binding.
Yes, next, Pramod Kumar. Paragraphs.
Now, my lord, the next judgment is, my lord,
Pramod Kumar.
yes, 2008 7 SCC 153.
Paras.
Lord, paragraph 29, 30.
30.
Paragraph 29, 30, and 31.
Identical issue.
Identical issues.
Next,
Now,
Krishna.
my lord, next, my lord,
Krishna Jadhav.
now, my lord, 1994 4 SCC 165.
Yes.
Now, my lord, kindly, my lord, allow me, my lord, to place these paragraphs. Yes.
Paragraphs.
Paragraph, my lord, I'm just placing to your lordship, my lord, paragraph 16 to 21 and 23. Page 40.
Yes.
My lord, kindly allow.
On what proposition?
This is the, my lord, identical case with this case.
So very good. We shall look into it.
Kindly, my lord, one paragraph. My lord, kindly, may I just place it.
Which paragraph?
Paragraph 16, my lord, kindly see. Paragraph 16, 17, and 18.
Page, running page.
Running page 49, 49.
Yes.
It says, my lord, having regard to all above, the irresistible conclusion is fraud has reached its crescendo, deeds as soul of this as inconceivable, much less could be perpetrated. We are
Acha, don't remind us Shakespeare. Let us go to the next.
now we'll next paragraph 17. We'll kindly have a look. Paragraph 17 and 19. If you look, I am not present. Now we'll next, my lord.
Yes. Vishwaranjan Sahu.
Vishwaranjan Sahu and my lord.
Paragraphs.
That's page 53. Agree, sir. Agree. This is 1996 5 SSC 365.
Yes, paragraphs.
Paragraph 3.
Speak.
This is not in respect of principle of natural justice. But it is not an unruly horse. There is. Now, my lord, next, my lord, page 56.
Gunwant Kaur.
Yes.
Paragraphs.
1969 3 SCC 769.
You said 96 3 SCC. Gunwant Kaur.
Gunman Kaur, my lord, 1969 3 SCC 769, page 56. Page 56. Next judgment.
You have given it 1996.
In the index.
In the index.
Sorry.
হবে না এত judgment. Yes, what is the year?
My lord, can you turn page 56?
1967.
1969 3 SCC
Hmm.
769.
You have referred 96 3.
My lord, paragraph 14, 15 and 16.
On the proposal.
On the point, my lord, the power of the court, my lord, under Article 226 of the Constitution of India. My lord, 2007, volume 4 SSC. Volume 4 SSC, page 54. Paragraph 26, 27, 28, 31 and 32.
Yes, next. 1815 SCC 463. Paras.
My lord, 2018-15 SSC 463.
Paragraphs.
Paragraph 24 and 25.
Yes.
2018-15 SSC, page 463.
Then 2010 volume 13 SCC 255. Paras.
97. Joseph Purnam.
Paras.
2010 13 SCC 255. Paragraph 25 and 27.
আরেকটা কি বললো 10 একটা 3 13 কি সব বলছো
Now, my lord, kindly text, my lord, next one, my lord,
3 13 দুটো বলেছে
2010 13 SCC, my lord, 255.
Got it.
Yes. Next, my lord, 2014 SCC online Tripura 291.
Paras.
My lord, kindly read, my lord, kindly allow me, my lord, to place few paragraphs of the similar facts. My lord, where to 10,000 and more, my lord,
Paragraph.
paragraph, my lord, 2014 SCC online Tripura 291. My lord, paragraph, my lord, 102, 103, 116, 117, 118, 119, 121, 123 and 124. Now, my lord, kindly takes, my lord, two paragraphs, my lord, I will cite. My lord, kindly turn, my lord, running page 187. And Amar, yeah.
Yes.
Now, paragraph 102, my lord, it says, my lord, on perusal of these samples representations, which you have given above, it is more than obvious that the selections have been totally unfair. The manner in which the interviews were held can be gauged from the facts that on certain days, as many as 300 candidates were called for interview, assuming that after the break of the interview board sat for 10 hours, that is 600 minutes, and this would give barely 2 minutes per candidate. In 2 minutes, one candidate has to leave, another candidate has to step in the room, which the member of the selection interview board be asked to take a seat. The 2 minutes will be over during this process and it is obvious that the interview were a total sham. Now, my lord, kindly text me, lord, the page, paragraph 116, page 190.
Yes.
Now, my lord, may I just place it? Paragraph 116. We live in a country which is governed by the rule of law. The action of each and every official or the government functionaries has to be in accordance with the constitution. The rule of law is the golden thread which runs through our constitution. The two most important facets of the rule of law are fairness and equality. Every citizen has a right to equal opportunity of employment and equal treatment at the same time of selection. Nobody can deny this right to any citizen of the country, and if such right is denied, then this court will step in to ensure that justice is done. Next, my lord, paragraph 117. Paragraph 117, I am not reading the entire paragraph. Kindly take paragraph 117, last 6 lines. In the present case, the sentence starts with, my lord, in the present case, the less said about the selection process as better. We, with regard to every category of teachers and with every subdivision and division, have been given example which clearly show that there is no method followed by the state in making appointments, and it is more than apparent to us that the appointments have been made on totally extraneous basis without considering the future of the poor students or aspirants of unemployed youth. The whole selection process was a cruel joke on the youth of Tripura, but it is also a cruel joke on the youth of West Bengal. Now, my lord, paragraph 118, it says, my lord, that this country, it has to be developed that needs great teacher. The teachers are gurus, and teachers are are the guides. The teachers are the mentors, teachers are the philosophers, and it is these teachers who will hold the finger of each child, teach the child, and then lead to the child towards hopefully a bright future. If the selection of teachers is unfair, then we are headed for a society which will be an unfair society.
So ultimately, what the court did?
Now, ultimately set aside. Entire selection was set aside. Now, kindly on page 192.
Yes.
Relief. It starts at page 191. Page 121, relief. 191, bottom. Has you also got in that?
Yes.
It has been urged that even if we set aside the selections, our judgment should be the prospective in nature. It has also been argued by Shankar Dev's London Senior Counsel for the petitioner that those portions of the policy which are bad may be severed and those portions which can be upheld can be retained. But the appointments already made need not be disturbed. Reliance has been placed such and such, such and such. These judgments have no applicability to the cases in hand, and we are not at all in agreement with
So
this
was
submission.
this challenged?
Yes, Supreme Court upheld it. Next, that is, my lord, page 196.
One 196 is against this judgment.
Yes, yes. 2028 SSC, page 6. 2028 SSC, page 67.
How can that?
Now, page 198. Your lordship would find, my lord.
Just এটা কবে হবে judgment টা? Titular judgment টা কবে হবে?
Well, this is, my lord, famous or infamous of Tripura 10,000 teachers recruitment scam.
May 2014. 7th May 2014 order was assailed.
Yes.
The cause title gives
My
the
lord,
name.
different appeals were filed, my lord. Subsequently, my lord, kindly see, my lord, page 198. Your lordship would find, my lord. This is the appeal, my lord. Your lordship would find paragraph 2. It says, my lord, selection of 10,323 teachers made by the government of Tripura pursuant to the advertisement issued in 2002, 2006, 2009 was subject matter of the challenge before the High Court at Tripura in Tanmay Nak.
Which paragraph you want citing on this?
Now, my lord, in this judgment, my lord, Supreme Court, my lord, endorsed the view taken by the
Very good.
Tripura High
Give us the relevant paragraphs now. 2020 volume 8 SCC page 67.
paragraph 17 and 18.
Very good. Next.
My lord, may I just place the paragraph 17?
No, we shall go into that. 17 and 18. We have taken note. Yes, next one.
Next one, my lord, 2010 10 SCC 677, page 208 of this compilation.
Yes, paragraph.
So, my lord, your lordship will not allow me, my lord, to place this judgment, my lord, as because, my lord, in this judgment, my lord, 160,
You are-
160.
I don't understand. After this also, if you don't see the, tell us the paragraph.
Paragraphs is, my lord,
to it.
26 to 37.
Yes, you tell us that.
26 to 37. Well, one paragraph, my lord, kindly have a look, my lord, page 217, paragraph 37. It says, my lord, section 165 of the Evidence Act 1872 empowers the court.
Paragraph.
Paragraph 37, my lord, page 217.
Hmm.
At the bottom, your lord should get
Yes.
it. Now, my lord, it says, my lord, section 165 of the Evidence Act 1872 empowers the court to ask the question relevant, irrelevant, related, unrelated to the case to the party to ascertain the true facts. The party may not answer the question, but it is not permitted to tell the court that the questions put to him is irrelevant or the facts of the court wants to ascertain are not in issue. The exercise of power is necessary for the reasons of that the judgment of the court is to be based on relevant facts which have been duly proved. A court in any case cannot admit illegal and inadmissible evidence for basing its decision. It is an extraordinary power conferred upon the court to elicit the truth and to act in the interest of justice. A wide discretion has been conferred on the court to act on the exigencies of the justice required. Thus, in order to discover and to obtain proper proof of the relevant facts, the court can ask the questions to the parties concerned at any time and in any form. Every trial is a voyage of discovery in which the truth is the quest. Therefore, the power is to be exercised with an object to subserve the cause of justice and public interest, and for getting the evidence in aid of a just decision and to uphold the truth. The purpose being for to secure justice by full discovery of the truth and accurate knowledge of the facts, the court can put questions to the parties except those which fall within the exceptions
Yes.
condensed. So, my lord, learned judge was absolutely right in asking the questions and, my lord, just to reveal the truth. My lord, your lordship, my lord, kindly consider, my lord, today one thing. My lord, the
You finish
symbol
your-
of justice.
Finish of these two, then you say. 1414 SCC 745.
Now, my lord,
This is paragraphs.
this is, my lord, page 234.